There's nothing more powerful than the odor of mendacity.
And welcome back Inside the Law, everyone. I'm your host, Philip Holloway. This is the channel, the LawTube channel, where we take you inside the real criminal justice system, not just the one that you might think we have if all you do is watch TV and the movies or even cable news. We're going to take you inside the real justice system to show you what it's really like. And of course, here inside the law, we do that in the context of actual real cases that are usually in the news, because there's always something we can learn. It might be good, it might be bad, and it might even expose the sometimes ugly underbelly of the criminal justice system. But hey, we're here to speak the truth. Now, speaking of speaking, what I'm doing right now is an example of exercising my First Amendment rights to free speech and to associate with all of you here who are watching us live or perhaps even on the replay, but we are still associating with one another. Sometimes the rights of people to speak and to offer their opinions and to engage in the constitutionally protected free speech that we all enjoy, sometimes that right gets tangled up in other rights, other interests. And by that, I mean the interests of the state. And by that, I'm not just referring to prosecutors, but the state in general in making sure that everybody gets a fair trial. Now, that being said, there's lots of ways that courts can make sure that people have a fair trial other than a gag order. Now, here, what we have, there's lots of motions that have been filed in this Young Thug case, and we've talked about a lot of them on previous shows here inside the law, and we'll be talking about some more of them, I'm sure, in the future. But today, we're going to be taking an additional look at the state's motion for a gag order in the Young Thug YSL racketeering case in Fulton County. This, of course, is Fani Willis' office. This is a Fani Willis prosecution. She may not be the one in the courtroom, but you better believe this has got her fingerprints all over it. She's the one who is the brainchild behind this. And so everything that her prosecutors do can be attributed to her. All right. So let me set this up for you. We've got a new judge. We had, all kinds of legal wranglings. There was a huge kerfuffle about the last judge. He had this illegal ex parte private meeting with Fani Willis prosecutors back in his office, browbeat a witness into waiving his Fifth Amendment privilege that he, through his lawyer, was trying to assert. And they together sort of browbeat him into continuing to testify. There was eventually a motion to recuse. This went to the Georgia Supreme Court. It wasn't exactly granted, but our friend Doug Weinstein, who we'll talk more about today, he got some good guidance from the Supreme Court that ultimately led to Judge Glanville sending the motion to recuse to another judge who granted the motion to recuse. And then the case was transferred to yet another judge who recused herself. And now we're with an entirely separate judge. And if you couldn't follow all that, just watch some previous live streams or get yourself a whiteboard because you'll need it to follow all the ins and outs of this. But where we are now, the new judge has invited the parties to submit any additional motions. And one of the motions that the state filed was this motion for a gag order. So let me go ahead and get that pulled up for you right now. And by the way, welcome to all of the 219 folks that are in here now live, and those who may join later, and of course those who may watch on replay. Here we have the state's motion to restrict extrajudicial statements. That's just a fancy legalese way of saying we want a gag order. Now, there's not much to this. Now, there's the name of the new judge, Judge Paige Whitaker. The state of Georgia is asking the court to prohibit the lawyers from making extrajudicial, that's out of court statements that a reasonable person would believe to be disseminated by means of public communications if the lawyer knows or reasonably should know that it will have a substantial likelihood, not just a likelihood, but it has to be a substantial likelihood of materially prejudicing, not just merely prejudicing, but materially prejudicing an adjudicative proceeding in the matter. Now, there's a lot there. And what it doesn't say, the prosecutors would have you believe that that rule prevents lawyers from talking outside of court at all, but it doesn't. Speaking of talking out of court, this is coming from Fani Willis' office. This is the same Fani Willis who loves to go out on the courthouse steps and in the wells of churches and all over places, all over TV, to talk bad about people that she's actively prosecuting in the same county where the jury pool is comprised. She calls the lawyers for these people liars, and she slimes them. But her office now wants to ask these lawyers who have done nothing wrong, wants to ask this court to silence them. And she cites this Georgia Rule of Professional Conduct, which says what I just said, but it's not an outright prohibition. First off, on its very face, it says that if the lawyer knows or reasonably should know that it will have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. So it's not just a likelihood, it's got to be a substantial likelihood. Okay. And it's got to not be mere prejudice, but it has to materially prejudice. So it's got to be very prejudicial, and there's got to be a high likelihood of it. And when you've got a jury that's been instructed, and we know that they don't always follow instructions, but presumably they do. They've all been instructed not to watch this channel, not to watch other channels, not to watch the news, not to consume any media about this case. And if they're following instructions, then this is all irrelevant anyway. But anyway, the state goes on to cite as some examples the statement of Brian Steele, who represents Young Thug, Jeffrey Williams, who Steele says Williams is innocent of the charges, and to clear his name, he sought a speedy trial, one in which he would receive the constitutional guarantees of a fair trial and an impartial judge presiding and ethical prosecutors. Sadly, Glanville and the prosecutors have run afoul of their duties under the law. Mr. Williams is grateful that that the reviewing court agreed with him and entered the order recusing and disqualifying Glanville from presiding over the case. We look forward to proceeding with a fair trial judge who will fairly and faithfully follow the law. Okay. Nothing wrong with that statement. Okay. Nothing at all wrong with that. The prosecutors, though, cite to that. They cite to a YouTube video where Young Thug's other attorney, co-counsel Keith Adams, made a YouTube video, and Exhibit C, which is the comment by, I guess it's in the Associated Press. It says, while I respect Judge Glanville and his service to the community, he simply became biased over the course of this case. Kendrick's lawyer, Doug Weinstein, said in an email, he added that he looks forward to trying the case before an unbiased judge. But he said the only just outcome at this point is a mistrial and a bond for Kendrick. And these, by the way, if you notice, he said this in an email apparently to the Associated Press. He said the same damn thing in court many, many times. So, it's not like there's anything new here. These are things that have been said in court already. So what's the big deal that they're saying it on YouTube or they're saying it to the Associated Press? These things have already been said. Here again, they cite to Doug Weinstein discusses live with journalists on YouTube. They don't really say what specific statements. They just want the judge apparently to come in here and watch the whole thing for herself and figure out what she can find. So they go on to cite a few YouTube examples and things like that. So that is, my friends, that is the state's motion. Now, let me show you an example, if I may, very briefly, of the type of speech and the type of extrajudicial commentary that the state would have the judge to block. Recently, a couple of times actually, but just in the last couple of weeks, Doug Weinstein has appeared here inside the law to explain basically his brilliant strategy of how to get Judge Glanville ultimately off the case. So let me take just a moment and show you just a couple of minutes of what this is an example of what the state would have the judge order Doug and the other lawyers not to do. I want to go ahead at this time and please, a round of applause. I'm going to bring in Doug Weinstein and our friend Rachel Kaufman. Good afternoon, guys. How are you?
Hey, good afternoon, Phil. How are you doing? Thank you for having me on.
Yeah, I know Rachel is also traveling. Doug, thank you for sharing. Both of you guys, thanks for sharing some of your Saturday. Doug is, I called Doug one of the architects of this, but he'll be the first to tell you he's not the only one, obviously, that's working on this. He is the one who got these rulings from the Georgia Supreme Court, and he doesn't have to answer this or speak to it. But what I can tell you is that when you've got multiple co-defendants, the lawyers, where they can, and they can't always because their interests are not always aligned with every other defendant, but where they can, they collaborate, they cooperate. And I would suspect that there's been some collaboration and cooperation from many members of the various defense teams. So this is certainly not something I'm sure Doug is saying is all him, but his name's on it. And Doug, that's why you're here, buddy.
Oh, well, thank you. Yeah, obviously we talk behind the scenes about plans and we don't always agree, but we do always discuss things with each other as to what we're going to do. So nothing's a surprise to any of us.
Well,
and I don't think any of my co-defendants counsel, they were surprised by this filing.
No, I wasn't surprised either, and I predicted it. So you heard most of what I was getting into here, I'm sure. Did I get anything wrong? Is there anything that you want to add to that so far? Because I do want to talk more about what's going on with your current efforts, because, I'll let you explain it, but I know that the mandamus in Superior Court is still pending. But as far as what we've gone over so far, what do I need to add to any of that?
I don't think anything other than, if I can sum it up simply.
Please.
On the 10th was the ex parte hearing. On the 12th, I filed my motion with Judge Glanville for him to recuse himself. He didn't follow Rule 25 like he was supposed to. On the 12th, I explained to him that I didn't believe he was following Rule 25. He basically said he didn't care and continued to rule against me without going through the proper steps. So on the 14th, he came out with his order, basically making it official that he was ruling against me. But then he did make some of the requisite findings under this Rule 25, all of which were in favor of my client. The next week, I was out with COVID and sat in my bed and drafted this petition to the Supreme Court. I was
wondering where you found the time. I'm glad you
found it.
I want to chime in on that. So
yeah, please.
As a sole practitioner, there's not many opportunities where you have a trial that's going on this long, where you have enough collaboration from other attorneys that you can take the time to really check on these rulings from the court they seem unfair as a defense attorney, but you're preparing for the witness the next day. And so what's been happening for so long and why Judge Glanville, in my opinion, so far has just been pretty flippant about these rulings, thinking that it is par for the course. This is usual, normal behavior from the bench that very rarely gets challenged, because as sole practitioners, if you're trying a case, a lot of us, aren't on these high profile cases where we're being paid enough to really even, we've got other cases, you're juggling a million things and you can't take the time to write. I'm so glad that you did, Doug, because the fact that the judge thought that all of this was just going to go away, that it would all just be fine. That's how it usually goes for him.
Right. Judge Glanville's usual. That's exactly right. And Judge Glanville, he'll say this from the bench frequently, I would say. He'll make a ruling, and if you disagree with him or you think he's made the wrong ruling, he'll say, if I've made the wrong ruling, the Court of Appeals will look at it, they can overrule me, and I can live with that. And that's why I think, Rachel, you're saying it's a flippant.
All right. So that was from a couple of weeks ago where Doug and our friend Rachel both were with us. And Doug was explaining, as you just heard, sort of the backstory of how the recusal, got before the Supreme Court by virtue of a vehicle we would call a mandamus. It wasn't granted, but the Supreme Court gave him some great language that said, if this is filed in the Fulton County Superior Court, Judge Glanville will have no choice but to have another judge hear it, and so on and so forth, to the point that Glanville got the message. Okay. And Glanville voluntarily then recused himself. So now here we are. But the benefit, of having Doug come on here and explain to all of us, because courtrooms are supposed to be open to the public. And I think understanding what goes on in the court is part and parcel of that. Okay. So Doug has a First Amendment right to come here and to talk to you guys and to talk to me about the things that are going on in an open and transparent court system. The prosecutors want to take that away from Doug. And this is, in the law, we call this a prior restraint. And I'm going to get into that just a minute more. But in First Amendment jurisprudence, the phrase prior restraints is when you ask a judge to order somebody not to say something before they would have said it. It's different than, say, punishing something that's said after they say it. Not all things are protected speech. Most things are. A lot of things are. A lot of really repulsive things are protected speech. So to the extent that there are things that you might say that you could be somehow punished for, maybe by way of contempt or whatever, the courts would prefer the judges to deal with it after it happens versus to restrain that speech prior to the speech having occurred. Hope that makes sense. And look, in order to illustrate this, before I get into Doug's brilliant and scathing response, I want to say welcome to all the people who are in here now who may be just joining us. This is Inside the Law, where we take you inside the real justice system using real examples from real life to hopefully learn some very real lessons. And also, before I forget, I want to say thank you to all the people who have supported this channel by way of memberships or super chats, or perhaps by following the links that are provided in the show descriptions. That's the kind of support that helps me continue to bring new and better content to you, so that we can all continue to learn about the real justice system. So thank you to all of you all for all of your support. Now, before we go any further, let's take a look. Now, this is a case involving a very high profile trial or criminal prosecution that took place some years ago involving a cold case. It's the cold case murder of a Georgia teacher and beauty queen by the name of Tara Grinstead. Those of you who have been following me for a while, you might recognize that, because that was from season 1 of our podcast, Up and Vanished, where I was a contributor, sort of the legal analyst for season 1, where we covered all of this. And, fast forward to the end, and I won't tell you in case you don't know all of this, but our friend Ashley Merchant wound up defending the defendant in this case, Ryan Alexander Duke. But before she was involved in the case and before there was a trial, his public defender attorney asked the court to issue a gag order, because there were podcasts like us that were poking around and they didn't want to have to deal with us. The news media was all over this case, both local and national print media, television media, cable news media, you name it. Anybody with an iPhone that could record was down there trying to record on this thing, and they were trying to get the lawyers to talk about it and everybody else. And so I won't speculate. It's not relevant as to the reasons why I think it happened, but nevertheless, the Superior Court down in Irwin County, Georgia, issued this sweeping gag order, and it was appealed. And the appeal was decided on March 5th of 2018. So this is pretty new law, and this is from the Supreme Court of the state of Georgia. Former Justice now Keith Blackwell, who's also a friend of mine, known him a long time. He's also a Federalist Society member, just like our current trial judge. I don't know that that's relevant to anything. It just popped into my head, so I thought I would share it. All right, so this is an appeal from a gag order, which restrains the lawyers in a murder case from making extrajudicial, outside of court, public statements on subjects related to the murder case for so long as the case remains pending. Justice Blackwell informs us that a gag order like this one may be constitutionally permissible in exceptional circumstances. And I'll skip over all the facts related to the case. You guys can research that on your own. It's a fantastic, I guess, case to learn a lot about the justice system from. It's a horrible case in the sense of the facts of the case and what happened to this poor young woman. But the case itself, the legal machinations are fascinating, and a lot of you probably are familiar with it. But in any event, I look here in footnote number 1. I always like to look in the footnotes. You find very interesting information sometimes tucked away in footnotes. The Superior Court also placed the motion for a gag order. Remember, I just showed you the motion filed in Fulton County for the gag order in this Young Thug case. But in this particular case, the motion that was filed was placed under seal. In other words, the court sealed it so that it was not available for the public to view. Just like you and I, we all just looked at together and we viewed the motion filed in this case. In this Duke case, we couldn't have even done that because the motion itself was filed under seal. See, courts are supposed to be more or less transparent. And in this particular instance, we're starting to see that, there was a lot of things that were not transparent. And for reasons that we'll get into, the court just doesn't really like that. It says it was transmitted under seal to this court, the Supreme Court of Georgia, as part of the record. We have reviewed the sealed motion, and there is nothing in it that is confidential or likely to prejudice the defendant in any way. Accordingly, we direct that portion of the record to be unsealed. And they cite this other case, and it says discussing the right of public access to judicial records. So here in a footnote, we see that the court is leaning in favor of transparency and openness in the judicial process. The Superior Court issued this gag order without an evidentiary hearing, but it nevertheless found that, quote, this case is high profile and has generated extensive media coverage. The trial court said there's a reasonable likelihood that Duke's right to a fair trial and impartial jury may be prejudiced by extrajudicial statements. And for that reason, an order restricting statements made outside the courtroom is necessary and proper. A bunch of news organizations challenged this thing really quickly. They all intervened and they filed motions. They had hearings in the trial court, and the court denied those, except the trial court did modify the gag order a little bit, but it went up on appeal. And ultimately, and I looked at this earlier, most of it is not pertinent to our discussion here, but the court does nevertheless give us some good information that we can use in understanding what's going on in the Young Thug case. So here they talk about a discussion on the standard of review. They refer to this as prior restraint, okay? And then they go on here later to talk about this gag order is a prior restraint of those to whom it applies. Although prior restraints are not unconstitutional in all circumstances, they are presumptively unconstitutional. Let me pause for a minute, make sure you understand what I'm saying here. The motion, the gag order that Fani Willis office is asking for is presumptively unconstitutional. So they're asking the judge to do something that the Supreme Court has already told them is presumptively unconstitutional. And if they just read the entirety of this opinion, I don't think there's any way the judge could reasonably grant the state's motion. Anyway, because this is one of the most, if not the most recent ruling in Georgia on the issue of these gag orders, but in the state of Georgia, they are presumptively unconstitutional. And here in the footnote, they give more discussion about what prior restraint means. The term prior restraint is used to describe administrative and judicial orders forbidding certain communications when used in advance of the time that such communications are to occur. A statement directed against participants in a judicial proceeding, such as Doug Weinstein, that prohibits them under the penalty of contempt from making statements that they would otherwise be perfectly free to make, that would certainly constitute a prior restraint. Justice Blackwell goes on to tell us that prior restraints on speech and publication are the most serious and the least tolerable infringement on First Amendment rights. The proponent of a prior restraint bears a heavy burden of showing justification for the imposition of such a prior restraint. You see where this is going? There's a heavy burden. And again, most of this is a long opinion, guys. I'm certainly not going to go through all of it with you. But the bottom line is they go on here, they point out here on page 21, pretrial publicity, even pervasive or adverse publicity, does not inevitably lead to an unfair trial. And at the end of the day, the Supreme Court, they go on to say that, the judgment is vacated. All the justices concur except one who didn't participate for whatever reason. So it was a unanimous opinion. The gag order is the modified gag order was vacated. And they go on at the very bottom to say, although it appears that the modified gag order should have superseded the original gag order, the language doesn't say it. So they say, to the extent the original gag order might still be in effect, we're going to go ahead and vacate and toss that one out as well. They don't like gag orders. In Georgia, gag orders are presumed to be unconstitutional. All right. Now, let's get rid of that opinion and let me see if I can find and add to the screen Doug's opposition. Here it is. This is the opposition to the state's gag order. Before we move any further, thanks again for everybody who's here with us live and of course on replay. I'm knocking on the door of I'm not quite there yet, but I'm approaching 50,000 subscribers. And so for those of you who might be watching and haven't subscribed, please not only like this video, it helps others find this video and this channel. Go ahead and subscribe if you like this content. If you have an interest in sort of learning about the real justice system, you're in the right place. Consider subscribing to this channel. And by the way, tell your friends and your family and anybody else that you can think of that might have an interest here. Please go ahead and subscribe because I'd really like to go ahead and celebrate hitting that 50,000 subscriber mark. All right. Here we go. Doug Weinstein and his opposition. Now, Doug's opposition is short and it is sweet, but it is spectacular and it is blistering. I mean, it's embarrassing. If I were the prosecutors and I read this, I would be ashamed. One thing I like about Doug is he's very creative in his writing. And so he starts out here quoting Winston Churchill. And here's the quote. "Everyone is in favor of free speech. Hardly a day passes without it being extolled. But some people's idea of it is that they are free to say what they like. But if anyone says anything back, that is an outrage." Sir Winston Churchill. Nothing requires lawyers to only cite legal precedent. Okay. You can cite anything that you want. It's your brief. Be creative with it. And by citing Winston Churchill right out of the gate, Doug makes an excellent point and sort of frames where he's going for the rest of this. The next person he quotes is Fani Willis. And her quote is from a press conference from August 29th, 2022. And guys, if I could do this in Fani Willis's voice, I would, but I can't. So I'm not even going to try. But can you try to envision in your mind, if you can tolerate it, try to envision and hear this in the voice of Fani Willis. I think if you decide to admit your crimes over a beat, I'm going to use it. I'm not targeting anyone. You do not get to commit crimes in my county and then decide to brag on it, which you do that for a form of intimidation and to further the gain and to not be held responsible. And Doug identifies the speaker there as the Honorable Fani Willis, Fulton County District Attorney, press conference of August 29th, 2022. He goes on to say, free speech for me, but not for thee, is the current position advocated by the Fulton County District Attorney. This should not be surprising to anybody that's paid attention to the present case over the last 19 months of trial, and we're nowhere near ending it, by the way, unless the judge grants the motion for mistrial. The state would apparently like the present trial to be conducted in secret, with proceedings happening in secret, hidden chambers outside the prying eyes of the press and the public. The state has repeatedly sought the secreting of witnesses' identities, even in instances where the state has made no showing of risk to the witness. After attacking the integrity and respective counsels for defendants and witnesses, e.g., repeatedly calling the Honorable Brian Steele a liar, it's kind of like, this is kind of like where Fani Willis called Ashley Merchant a liar. I'm starting to see maybe a pattern out of this DA's office, and accusing the Honorable Jonathan Melnick of working for defendants rather than his client, Kenneth Copeland, which is Little Woody, right? The state now turns its attention to counsel for Deamonte Kendrick, in other words, Doug Weinstein. But to paraphrase President Truman, here he's gone from Winston Churchill to citing Fani Willis, and now he's citing President Truman. But to paraphrase President Truman, counsel does not give the state hell. Counsel just tells the truth about them, and they think that it's hell. I mean, Doug is just not holding, he's very respectful and he's very polite, but he is not holding anything back. Not holding anything back. All right, let's keep going and see what else Doug has to say. He refers to their piddly little 1.5 page motion. The state cites to Rule 3.6 of the Georgia Bar Rules, and they cherry pick comments to the rule to support their motion to, quote, instruct the defense to refrain from making extrajudicial statements about the case. Importantly, no case law is cited. I mean, what case law could they have? They certainly did not want to cite the State versus Duke ruling that we went over from the Georgia Supreme Court a few minutes ago. And they did not propose any specific language for any order that would be finely tuned. They just gave their 1.5 little page motion, if you can call it that. It says the state accurately quotes Rule 3.6, barring attorneys from making extrajudicial comments that a lawyer knows or reasonably should know have a substantial likelihood of materially prejudicing an adjudicative proceeding in the matter. The state provides no specific quotes of Kendrick's counsel, i.e. me, not me, Phil Holloway, but me, Doug Weinstein, that might be barred by Rule 3.6. Instead, the state invites the court to go on a scavenger hunt amongst 208 minutes of interviews, I guess, to find statements by Kendrick's counsel that might violate the rule. He says the court should decline this invitation. The state doesn't make any arguments that any statement by Kendrick's counsel meets the elements of Rule 3.6. Instead, they simply offer one conclusory statement. There is no argument that any statement made by Kendrick's counsel was known to or should have been known to have a substantial likelihood of materially prejudicing this jury. He points out, as I did at the beginning of this stream, that the jury has been instructed at the conclusion of every day of trial by Judge Glanville, while he was still on the case, through his, quote, ad nauseum admonitions to not discuss the case with others or with each other. They have been instructed daily not to consume any media about this case. No statement made by counsel for the defendants can be heard by the jury in order to prejudice the jury. Now, Doug drops footnote number 1. So let's just go ahead and skip ahead and see what that footnote, oh boy, this is a good one. Footnote number 1. The only improper prejudice to the jury has been through the repeated eye rolling and facial expressions of ADA Love, who is sitting mere feet from the jurors. Wow. Well, that's a good use of a footnote. The only improper prejudice to the jury has been through the repeated eye rolling and facial expressions of ADA Love, who is sitting feet from the jurors. Now, I know that the lawyers in this case complained many times to Judge Glanville about this and other conduct that they felt was inappropriate by the prosecutor in the case. And Doug is doing a very good job here of succinctly informing the new judge that this is the kind of thing that's been going on. So part of what he's doing here, he's not just merely asking the judge to deny their motion. You see what he's doing here? He's educating the judge about what's been going on in this case from his perspective. So that, let's just say they bring the jury in next week. Maybe the judge is going to be on the lookout for any eye rolling to see if that occurs, right? And if it occurs, maybe do something about it. By the way, any of you who have kids, particularly teenagers, there's nothing more annoying than getting the eye roll, right? That's just, it's like the most, it's just an awful form of just rudeness and disrespect. And, you know, as much as it irritates us if our teenagers roll their eyes at us when we tell them to, you know, make sure you make good decisions and don't drive too fast and you get the eye roll. Well, you know, if you're a lawyer in court and the defendant is making an objection to something, and instead of professionally standing up and responding to the objection the way lawyers are trained, if you look over to the jury and you kind of roll your eyes and they see you doing it, that's an improper communication with the jury. I mean, so this is not frivolous stuff that Doug's talking about. If this stuff is going on, it's improper, and the judge ought to stop it. All right. Anyway, so the state conveniently fails to quote from the presumptively safe harbor comments included in Rule 3.6 that permit Kendrick's counsel to speak in public on his behalf. The comment reads that there are certain subjects which are more likely than not to have no material prejudicial effect on the proceeding. Thus, a lawyer may usually state information that is contained in the public record. So you remember I talked about this earlier, the things like when I showed you the clip of Doug coming here inside the law and telling us about, you know, what's going on in the case. This is all things that are in the public record. The exhibits that the state attached to their motion, where Brian Steele is saying things like, you know, we're looking for a fair judge and my client is innocent. Those are the same damn things he's been saying in court for months and months and months. So this information is already out there. And so Doug points out that each statement made by Kendrick's counsel relates to publicly available information in the public record of the present trial, which is being streamed daily to the public. To the extent that there are any remarks not specifically in the public record, the statements would be general remarks intended to demonstrate that Kendrick should not be on trial. Now here, Doug is getting into Justice Anthony Kennedy from the U.S. Supreme Court, and he's got some sites here. All right. By the way, I'm going to finish this response, but if there's any questions, for example, Taylor asks a question here. If you type question, it makes it easier for me to see. So I'm going to take just a minute and answer this question. Can the public make complaints to the Bar Association about Love and her unethical behaviors? If lawyers won't take action, hopefully the public can. Both should really be investigated and, in Taylor's opinion, disbarred. Well, look, I mean, I heard, let me see if I can find this. I heard that there was already going to be a bar complaint. Here you go.
And for an assertion to be made that I or Mr. Copeland are somehow being influenced by somebody over here is absolutely ridiculous. I take great offense to it, and I can tell Ms. Love that I am going to the state bar to report her for contacting a witness that she knows to be represented by counsel. She and I have had conversations about Kenneth Copeland.
All right, so that's just one example. Now, I don't know if that's Jonathan Melnick, by the way, Woody's former lawyer. I don't know if he followed through with that, but the answer to the question is yes. I mean, anybody can do it, but I'm not asking everybody to go out and flood the state bar with bar complaints. We're having a discussion about things that are happening in this case, so that we can learn something from them, right? So anyway, but that's a good example of when you flag these with the word question up front, it helps me. It's like our great moderator, Transplanted Texan, points out, starting out with the word question really helps me to see it. And of course, super chats are always starred, and those obviously are brought to my attention as well. So anyway, hopefully we'll have some good questions that we can get to here in just a few minutes when we are finished going over Doug's brilliant response. If Doug's watching now, and he does watch this, he's been on here, he's been a guest, he's a friend of mine, a colleague. I know he watches sometimes live and sometimes on replay. If I could add anything to this motion, it wouldn't be much. I might have cited that Duke, State versus Duke opinion that we started out with, that says these gag orders are presumptively unconstitutional. But otherwise, this is really, really good. Justice Kennedy rightfully understood the present situation that Kendrick and his counsel found themselves. Justice Kennedy writes, an attorney's duties do not begin inside the courtroom door. He or she cannot ignore the practical implications of a legal proceeding for the client. An attorney may take reasonable steps to defend a client's reputation and reduce the adverse consequences of an indictment, especially in the face of a prosecution that's deemed unjust or commenced perhaps with improper motives. A defense attorney may attempt to demonstrate in the court of public opinion that the client does not deserve to be tried. Okay. Up here, one paragraph above, Doug says any statements that he may have made that were not already included in the public record are general remarks intended to demonstrate that Kendrick should not be on trial. So here you have some support from the United States Supreme Court that says a defense attorney may say just that. Now, this is a case where apparently it's a lawyer versus the State Bar of Nevada. So there apparently was some type of bar discipline taken against an attorney, presumably by the name of Gentile, that went up to the Supreme Court, perhaps on First Amendment or other grounds. But this is where Justice Kennedy also states that the police, the prosecution, and other government officials and the community at large hold innumerable avenues for the dissemination of information adverse to a criminal defendant. By contrast, a defendant cannot speak without fear of incriminating himself and prejudicing his defense. And most criminal defendants have insufficient means to retain a public relations team, that it would be separate and apart from the defense counsel for the sole purpose of countering prosecution statements. So this is I think, a correct recognition that in addition to defending a client in front of a jury, a lawyer has the right, and I would say, frankly, the duty to protect that client's reputation as much as possible in the court of public opinion. This is why gag orders are presumptively unconstitutional. He continues to quote Kennedy, because attorneys participate in the criminal justice system and are trained in its complexities, they hold unique qualifications as a source of information about pending cases. Since lawyers are considered credible, are all lawyers considered automatically credible? Anyway, since lawyers are considered credible in regard to pending litigation in which they are engaged and are in one of the most knowledgeable positions, they are a crucial source of information and opinion. To the extent the press and the public rely on attorneys for information because the attorneys are well informed, this may prove the value to the public of speech by members of the bar. Okay. Remember that I showed you the clip of Doug coming on here. He was giving us, he was informing us. Okay. And this is exactly what Justice Kennedy was talking about. We rely on him because he's one of the lawyers involved in this case. He's well informed, and he is the great, crucial source of information about what's going on in this case. And Doug highlights this in italics. If the dangers of their speech arise from its persuasiveness, from their ability to explain judicial proceedings, or from the likelihood the speech will be believed, these are not the sort of dangers that can validate restrictions. In other words, the First Amendment does not permit suppression of speech simply because of its power to command assent. So if you're speaking the truth and what you're saying is persuasive, and it has a likelihood of being believed, that's not a good enough reason to silence the speech. And he goes on to point out this is the exact situation that Kendrick and his counsel find themselves in today. Kendrick is a public figure who's an artist in Fulton County. This makes Kendrick a target of the state. Kendrick is allowed to take reasonable steps to protect his reputation. Those steps may be taken by his counsel rather than through a public relations firm. Having smeared Kendrick and his reputation, the state wants to silence him, initially by placing a burden on his free speech rights to write about the world. What he's talking about is she being Fani Willis in her office, they're using the lyrics of some of these rap songs as evidence in the case. So this is a reference to that. So the state wants to silence him first by placing a burden on his free speech rights to write about the world in which he lives and the tragedies and the injustices around him. And now, secondly, by holding press conferences denouncing him and his writing, and that's the reference to the Fani Willis press conference at the beginning of his motion. And then thirdly, seeking to bar him from defending himself in the court of public opinion. So to summarize, Fani Willis wants to silence him by, prosecuting him for, at least in part, the language that he uses in his artistry and in his rap songs, the lyrics. And they want to smear him by holding press conferences where they denounce him and his writing. And then thirdly, they want to silence him by virtue of making his lawyer keep his mouth shut in the court of public opinion. All right. So there you have it. There's Doug's very well written motion in opposition to the state's petition for a gag order. All right. And our wonderful moderator has, I guess, provided a link. Thank you for doing that. I really appreciate it. All right, here's a question. I've got time for a little question and answer here. If a member of the bar is watching these proceedings, can he or she file a complaint for any of the numerous improprieties that Ms. Love has committed during the course of this trial? I'm not going to speak specifically about Ms. Love or any specific attorney, but I will tell you that as a general rule, the rules of ethics that govern attorneys, they actually have an affirmative requirement. If you're a member of the bar and you know another lawyer has violated an ethical rule, you're supposed to tell on them. You're supposed to inform the bar. I mean, in law school, the way we learned the golden rules, the bottom line of ethics is, act like Jesus would do and tell on your friends. Okay, so that was the two big things that, so there is an affirmative obligation actually to report other lawyers if you know they violate the rules. Is there any common sense reason the current judge can give for not granting a mistrial? What reasoning can she give that will make sense for deny? I don't know. Has she denied a mistrial? If that's happened, I haven't seen it. Maybe it's happened while we've been here live today. But I think that, judges, I will say, are particularly, they're hesitant to grant mistrials, particularly when you're, let's say 19 months into a trial, because think about all the time and resources that, would be just essentially out the window. On the other hand, there's some merit in the idea of not putting good money after bad. And if the trial is so tainted at this point, may as well go ahead and cut your losses now and grant that mistrial. I think the mistrial should be granted. I think it should be granted after an evidentiary hearing where Judge Glanville and the prosecutors in this case are put under oath and have to testify as witnesses. That's what I think ought to happen. Jerome, thanks for the comment there. I appreciate that. I see a question here. Who are members of the state bar? Well, that would be any person who's licensed as an attorney in the state. Myself, certainly judges, prosecutors, anybody who holds a license with the state bar is a member. Now we have, there's inactive members, people that don't practice anymore, maybe retired lawyers that don't pay dues, but members of the bar generally are people that hold a law license, such as myself. I'm trying to scroll up. Bear with me. I want to see if there's any other questions that I missed that I might want to pluck out of here. It's a comment. And I saw the word bond in there because I wanted to point out among the other motions that are being considered are there renewed motions for bond. And I think that they're very compelling reasons why at this point bonds should be granted, because there's things you can do. If you're worried about somebody being a flight risk, well, I'm not saying they are flight risks, especially if there's strong ties to the community, but you can put people on ankle monitors and all kinds of stuff. But, after all this time, considering the conditions at the jail, I think there's a pretty strong argument to be made in favor of bond for at least most of the defendants. So thanks for pointing that out. All right. Looks like that's all the questions, the recent questions that I can see. We've gone over a lot today. If you take nothing else away from this, please take away the understanding that in Georgia, gag orders are presumed to be unconstitutional and should very rarely, if ever, be granted. There are rules in place, that through in terms of our rules of ethics that should control most of this. But when you silence somebody, particularly an attorney who's trying to manage their client's reputation in the court of public opinion, and if all they're doing is talking about things that have already been said in the courtroom, there's just no good reason to to silence that person. The First Amendment is important. It's more than just freedom of association or freedom of the press. It's and freedom of the speech. It's all of those things, and it is so vitally important that we give everybody the opportunity to say things, even if we disagree with them. Right? That's what the First Amendment is all about. If somebody says something and you disagree, then you get to voice your disagreement also in the public square, so to speak. In whether it's the actual public square or the virtual town square where we are now, which might also be social media, Twitter and Facebook, anything else. The answer to speech that you don't like is not to silence the speaker. The answer is to provide your viewpoint in addition, and to make your case, make it in a persuasive way so that the people who are the consumers in this marketplace of public ideas, the consumer will pick your opinion perhaps over the one that you don't like if you make your case better. So the answer is not to silence people, it's to allow people to state their case. So that's why this notion of prior restraint and gag orders and all this stuff in the criminal context is just not it's just not found. It's just not a good thing. It's not appropriate in most instances, and it ought to be denied. Thank you very much for the super chat there, Jerome. I do see a question here. If Judge Whitaker is going to grant a mistrial with prejudice, then she really doesn't have any reason to address the motions filed by the attorneys, does she? I guess not, because if she's going to grant everything else would be moot, right? If you grant the motion for mistrial, and it would be with prejudice if the one that's been filed is granted. Yes, that would absolutely make everything else moot. And so if it's a mistrial is granted, case is over. There's no issue. There's no reason to hear a bond motion because the case can't be retried, and the case should be over, and whoever's incarcerated on this indictment should be released. Now, it's worth noting that a prosecutor can appeal the granting of a mistrial, so there is always that to consider. But at least in the interim, if the mistrial is granted, everything else is apparently moot, and it is over with. And so that's a very good point. Melissa asks, is it really okay to deflect the case because attorneys are playing games? I don't know what you mean, Melissa, unfortunately, by playing games. I wish I could give you a better answer, but in general, the way to manage these things is through making the proper objection, whether it's a verbal objection in court or making your point in writing to the trial judge so that the trial judge can address whatever it is that you think that you are needing to have addressed. So without more information, I can't really if we're talking about the eye rolling, maybe that's what you're referring to. Yeah, I mean, that's the way to address that is to bring it to the court's attention, get it to stop, because it's something it's just not appropriate if it's happening. I'm not saying that it is, but they're saying that it's happening. They are concerned about it, and if the judge sees it, the judge needs to stop it. Pretty simple. All right. I want to say thanks again to all of you for being here today, and thanks for hanging out with me here inside the law. We're going to be back real soon because there's more motions and there's going to be more activity in coming days on this case, and we're going to do our best to keep you up to speed for all of it. But one thing that I want you to always remember, please don't be this guy.
Man, can I get the water or something? I'm so high right now, y'all. I'm about to go to sleep on y'all ass. I ain't gonna tell you no lie.
Yes, you may. You're gonna take a break. Hang in there.
All right. Thanks for spending your hour with me, guys. It's been a lot of fun. And remember, I go back and I watch the chat, and the chat's been great, but in the replay, I try to make sure that I go back and see what's been asked, and I'll try to address any questions I can. Of course, I can't respond to a chat when I watch it on replay, but ask questions in the comments to the video. And I answer a lot of them. I can't answer all of them. I don't have that much time, but I do answer a lot of questions. And I also will address comments as well. So, we do look at those things, and I want to hear what you've got to say. I want to hear what you think about what I've said. Maybe you disagree with what I've said. I want to hear that too. This is a free speech zone. It's not just me that gets to talk. You get to talk too. This is an ongoing discussion, not only with this video, but with all videos in the past. I check out the comments on videos that I made sometimes several months ago. So by all means, feel free to ask questions, and hopefully it'll get my attention and I'll be able to respond to it as best I can. But I want you to know that I appreciate each and every one of you. And of course, I always appreciate having your support, and just the fact that I've got 500 people willing to spend an hour with me here on a Friday afternoon means the world. And don't forget, hit the like button, hit the subscribe button, and tell all your friends. And I will see you here next time inside the law.